ותוכלו לראות עדכונים על ההרצאות הקרובות באתר שלנו. רוב ההרצאות התקיימו פה בימי חמישי ב-6, אבל לפעמים אנחנו נתכנס פה בימי חמישי ב-4. This was a general welcome to our cyber forum. This is the beginning of our second semester.
Okay.
It's also an open day at the university, so you may hear some announcements over the mic.
Yes,
it's not an alert, it's not an emergency, it's just...
I see that.
So this is just part of the celebration, an open day for students. Welcome, Martin. This is a great pleasure to welcome Martin Husovec from the University of Tilburg, from the Tilburg Institute for Law, Technology and Society, right?
Yep.
So this is a sister center to a Center for Law and Technology, and also for the center, this center, and this is another opportunity. This is the first event that we do in this center. It is a Center for Cyber Law and Policies. It is a university center. We're really happy to have you as our first speaker. Martin is a professor at the University of Tilburg and is working on innovation and civil liberties and many issues that really are at the focus of some reform initiatives here in Israel, especially related to online intermediaries. And he will talk to us today on some of the research and studies that he was doing related to a new book that was recently published. Do we have a copy to show the audience? So this is, the name of the book is Injunctions Against Intermediaries in the European Union, Accountable but Not Liable, which was published by Cambridge University Press, and congratulations for the publication.
Thank you.
We will hear from you for about half an hour, and then we're going to hear from Jan Pearl, who is a lecturer at Netanya College, and she's also a senior researcher here at the Center for Cyber Law and Policy. Welcome.
Okay, thank you very much. Thank you. I'm first taking the mic, so this can be recorded. Okay, does this work? Does it work? Okay. So I'll feel a little bit like a singer in oldies. I hope that is fine. Okay, so great pleasure being here. I heard about the context of what is happening in Israel these days, and that basically what I'll be talking about today very much touches upon what is happening here. So that makes me very happy, because basically it makes what I talk about very relevant to, and also might be a little bit of an example where you might want to go, might not want to go. I leave that up to you to decide. But first of all, once again, thanks a lot for having me. And I'm very much looking forward to the conversation and discussion afterwards. So, do we have a clicker maybe just before, or do I need to? Perfect. Okay. So, So I'll be talking about injunctions against intermediaries in the European Union. And to give you a preview, so you already know from the very beginning what to expect, I'll be talking about this specific type of remedy that we developed in Europe and that is taking off these days, and something that is especially relevant in IP area. And this remedy is special because it allows plaintiffs to target also parties that did nothing wrong, legally speaking, and it allows the plaintiff to basically ask for certain positive steps of cooperation in the infringement enforcement. So the basis of this remedy is nothing like, did you do something wrong, dear addressee? It's only the fact that you are in a position to help the right owner, and that position is then used to establish obligations that are imposed on the intermediary. This all will become much more concrete. So what this is really, it's a duty imposed. You can call it a right to assistance, injunctions that is imposed Now, there were also some people who were saying, well, this is dynamite, or they were saying that the reach of this article is hardly foreseeable. And indeed, they were right, because eventually it turned out that this article does much more than just confirming the intuition that if intermediaries infringer himself, herself, then it should be also addressee of an injunction. What happened in the member states was basically some member states started experimenting with website blocking, and website blocking is really killer application for this provision. It really was what popularized this whole thing, because what started happening, we had the member states popping up with website blockings, and then right holders learning from each other, and suddenly we had great majority of member states issuing website blocking injunctions. So this really popularized the whole thing, but it's not the whole thing. So website blocking is just the start. It's not the entire framework. So what it turned out to be a policy intervention, which basically seeks accountability for help, also where no liability exists. And I'll show you in a second that these criteria here are applied so loosely that eventually it actually allows you to issue an injunction against anyone who provides a service which can be in some way used for infringing activity. Because eventually what the court arrived at is basically clarification, where the court says, well, basically this provision is there to make sure that the member states have an injunction against an intermediary, regardless of his liability in this specific case, and that these injunctions should make sure that right owners can ask for removal of infringing behavior, which is not too controversial, but also prevention of future wrongdoing. And this is where most of the stuff is happening. This is where I'll be showing you most about. So at the moment, it's pretty clear these injunctions are completely divorced of any liability of the addressees. They're very broad in how far they can go, and their main purpose is to police future wrongdoing. So that's what they're supposed to do. Well, many people thought, well, this is very novel, and this kind of goes against the history or what we had before. But if you look at a history, I looked at German law and British law, you find out that there is indeed actually some trace of these kind of measures. Not as far-reaching as we have them now, and certainly not as popular as we will have them now in IP, but they existed. In Germany, you have 100 years of case law where similar constellations were applying similar remedy, and in the UK also you had some equitable relief against innocent third parties, which was at first limited to information but then expanded. So it's not completely that this is without some backing in the history. Now, the real thing is about how far does it go, these measures. And I think this will be second to last abstract slide, and I go to examples. So I told you that the main purpose of these injunctions is to be proactive, to police future wrongdoing. Now, but there's still many flavors to how you can police future wrongdoing. You could say, well, you should just prevent that the same infringer infringes the same work, right? So we would call that double identity standard. You could also say, no, we want that a same infringer infringes similar type of work, so in the nature, so he doesn't infringe copyright again, but the same user. Or you could say, no, I don't want similar infringement with respect to this work to happen regardless of who the infringer is, right? And this, of course, is a very different scope, right? Whereas the first basically tells you, well, make sure that infringers don't repeat in the future the infringing behavior. Stay down standard basically tells you, well, make sure that there is no infringement with respect to this work again on the platform. And we have ongoing debate how far these measures go, but we are for sure at the Hilfiger standard, so we can police similar infringement by nature from the same trader, and this is confirmed by the court. We have debate to what extent it can also prescribe stay down. But some member states are already practicing stay down by means of injunctions. All right, so let me make this abstract, more concrete. But before, maybe one thing, in the European law, when we apply these remedies, basically the only limits that we have really are human rights. So statutory language is very little. It's not really a limiting factor here. It's the human rights that are really shaping this. And I'll show you that in a second. So let's start with the first example, website blocking, where I try to demonstrate some of the issues and how the system sort of works. So you have a typical website blocking scenario where you have a right owner, say Disney, goes to the court, and in the court it names AT&T as the defendant, right? Or pick your favorite ISP. And then it tells the court, well, I'd like the Pirate Bay to be blocked for your subscribers. So basically, your customers shouldn't be able to view Pirate Bay when they use your internet. Now, you argue that AT&T is an intermediary, no problem with that, whose services are used by third party. Now, the third party here is the Pirate Bay, not a user. So, Pirate Bay is using services of the AT&T to infringe the copyright. So that you can see already there that the relationship between who uses the service doesn't have to exist in terms of some commercial relationship, because the Pirate Bay hardly has any commercial relationship with AT&T. No, it just happens to be on the internet. So that tells you already how far that precondition goes. Okay, whose services are used to infringe? Well, if the Pirate Bay is infringing itself, say under secondary infringement doctrines, then, well, there is no problem. As a consequence, the cause of action is established, and we only have to discuss its limitations, right? We have to discuss in which form, under which conditions, how exactly. Now, if you look at Europe, we do everything. We don't have one specific approach. So we have courts that are very specific and say you will use this specific technology. There are these clauses in case of abuse. This is how this will be remunerated. This is how the cost will be split, and all of these things will be specified. Then you have member states that will basically say, well, this is the end goal, and you go and figure. Okay, so there are many different approaches within Europe how these injunctions are granted. So there is no single way. And if you're interested in this paper, we describe some of the differences in how this works in Europe. The most important thing, I think, for one point that I'd like to make about these measures overall, is that how it works with a cost allocation. So the main stream at the moment is that right owners, when they go to the court, they pay their own representation, right? So the legal representation, they pay the court fees. But then when it comes to the implementation side, it's all borne by the intermediaries. So what does it mean in the real world? Well, it means that intermediary, so the right owner can incur some cost, 5,000 to 10,000 euros for prosecuting one particular website. And then intermediary has to implement technology depending on what the court demands, if it demands something specific, and implement that technology. And as you know, there are different ways how you can block websites. More efficient, less efficient, DNS blocking, IP address blocking, many different ways how you can do this. Now, the important thing is that the Court of Justice, so the European top court, doesn't require that you show effectiveness. You don't have to show effectiveness, really. We have some threshold, but it's super low. So in reality, if you basically sue, it's assumed that the measure that you propose is kind of okay, and since who pays for the measure is the intermediary, the right owner doesn't really care too much about what's the cost of the measure. In fact, the bigger the intermediary, very often, the lower the cost of implementation because of the scale, and that's something I'd like to get back to in a second. So this is the main allocation of the cost. Now this triggers one problem. So you would be fine with having these measures from the welfare perspective, at least static welfare perspective, if you could believe that these blocks are only issued if the expected benefit is higher than the cost of having those measures, right? So if the expected benefit is higher than the cost of going to the court, paying for the fees, and also of implementing it. If that's true, then it wouldn't be, from at least static perspective, not really objectionable. The problem is that at the moment that's not how the incentive and how the system work, because the courts don't have enough information about what is the expected benefit of the block. They have no way of knowing, and there is no obligation on right owners to actually show what is the expected benefit of the block, whether they will save, whether they earn more money by basically driving people away from infringing behavior or not. There is no such thing. So basically they just rely on the fact that the right owner is interested and goes to the court. Right owner could know, what is the expected benefit. Of course, not with the precision, but they could anticipate maybe impact on sales. But they don't have to. So what do they make as the decision? Well, they go to the court and they say, well, as long as the expected benefit is higher than my own private cost, I'm willing to go to the court, right? The problem, of course, is that that's not the welfare function for us, the society, because we are interested in having those measures in place only in case the overall costs, including intermediaries costs, outweigh the benefits. And so that's the problem, which then perpetrates, and if in case this will be applied for many years to come, you basically have right owners going to the court. For them, as long as the benefit is higher than 10,000, they go to the court, ask for a block. Block is issued forever in many countries, and the block goes on. Maybe they realize on a way that it's actually a waste of money, but the intermediary still has to keep updating and implementing it, and the number of blocks grows. So there's no point in which there is a reconsideration whether this is effective or not. And so the problem is that the costs of the implementation are not taken into account, and the courts are not screening for it either. So what to do with that? Because you can basically arrive at a continuous waste of resources this way. So that's one problem, and I offer some solution to this at the very end. Okay, so that's one problem with website blocking and with these measures. Now let me show you the second problem that concerns also website blocking, but it's more nicely seen in the example of internet disconnections. So internet disconnection is something that you might be familiar with, because it was a time when this was popular to do among policymakers, to draft administrative legislations and to say, well, there will be 3 notifications, and in case it doesn't work out, then you'll be just disconnected, right? And some countries wasted awful lot of money on this, like France, and then turned out that is ineffective, so they terminated the whole process, and it doesn't really exist anymore. Well, these injunctions allow you to institute the same thing, except you don't have to argue before the parliament. You can just impose it in form of injunction. So what is happening that we have, for instance, Ireland. In Ireland, a right owner decided that instead of trying to institute legislation in the country, they would basically just go to the court and say, well, here it is, this is my list of rules, and I basically propose the graduating response scheme in form of injunction. And then the court goes and looks at it, okay, legal basis is there, right? So the subscribers are infringing, they're using service of the internet access provider who is an intermediary, so injunction can be given. Let's look at the limits. They look at the terms. They say, well, it looks fairly balanced because they receive only notifications, and there has to be then separate proceedings for disconnections. So at the very end, the Irish court at the first instance decided that, yeah, we can use these injunctions to actually impose the entire graduating response scheme. But wait a second. In other countries, they had to go through the entire legislative process, and they had to try to argue in the parliament and convince people that this is a good idea. Here, it's based on the proposal of a right owner and acceptance of the judge. And it's something that is still ongoing, so the system wasn't instituted yet because it's now under appeal before Court of Appeals. But it is, what you can see here, it is a worry that if you have a very broad cause of action, like the one that I've shown you, you have a problem that injunction can be basically used to legislate in a way, because you can institute all kinds of things by imposing them on the intermediary, because it's just very broad. The number of addressees is very broad, the scope of what you can ask for is very broad, so you can really use it in very creative ways. Now the other thing is that in many of these cases, the real affected party is not party of proceedings. So we had Spanish case about disconnection, where ISP was sued to disconnect a user. The user who was disconnected was not party to the proceedings. He was never notified of the proceedings, but his ISP was prohibited from contracting internet with him forever. He couldn't voice his concerns. And the same problem arrives in many of these disputes, because these parties are not the defendants. And unless the court feels that they should include these parties because they're affected, it very often happens that they are not. So that's a problem and challenge for rule of law. Okay, let me bring another problem. There seems to be many problems with this. Password locking. Okay. Wow, so quickly, real-time blocking. Well, there is a real-time blocking in the UK for soccer matches, so maybe they already know that I'm talking about these things. What is going on? So, Wi-Fi blocking is okay. Well, some shiny colors. So Wi-Fi locking is an interesting example because it shows yet another problem of these measures, is that well-intended cost-benefit analysis can turn out to be wrong in the long run. So let me tell you a story in this case. This is a story which took place in Germany. So in Germany we had in 2010 decision coming from the German Federal Supreme Court, and the decision was about a following issue. Corporate owners in the country were suing some open... are we now fine? Let's see.
Not extended all the time.
All right. So corporate owners decided that they will sue those people who open up their internet access. And their idea was that internet access, open wireless, is basically just simply easily misused by third parties for file sharing. Granted, yeah. So the court thought, okay, so maybe it would be a good idea to just force everyone to password protect his Wi-Fi, because after all, that prevents misuse, right? And it was a case concerning a private hotspot operator. Now, in addition, the court thought, okay, well, not only that it prevents misuse of Wi-Fi, but it also increased security of the user, because, well, password, so that it's not as easy to log into your communication. So it's actually a pretty good idea. So the court thought, okay, so let's have from now on a rule that an open wireless doesn't exist, and you need to have a password to protect it. Otherwise, you could receive cease and desist, which in Germany already cease and desist is subject to reimbursement. And basically, they send you the cease and desist when you have open wireless, and you have to pay money if someone was fired to file share. So as a consequence, what happened is that in Germany, open Wi-Fi basically went extinct. There is some open Wi-Fi at the moment, but it's just very limited. And as a consequence, the low availability of Wi-Fi is something what people started complaining about. They were like, yeah, but this is strange. So in all the other countries, you have open wireless. And there are many good things that you can do with open wireless. Why in our country? And the answer was copyright. So people started rebelling against this. And at some point, they even went to the parliament and basically went to the parliament saying, well, let's change this rule. So you legislator, let's change this rule. So they passed the amendment, and guess what? It did nothing. So they went to the parliament again, and they passed the law again, and did it change the law? Well, the judge who was deciding this case thinks it still did not change the law. But the point here is not about whether they were able to change this, is about the fact that basically the court set a standard, which was password protecting, for well-intended reasons, I would say, but it backfired because people realized there is much more value to open wireless than just what you just mentioned, and then plus the many other use cases than the one of the private user. And it had to be the legislator who would step in and try to change this outcome. So the problem was that what they didn't take into account really was maybe innovation. Maybe the fact that these things could be from the static cost-benefit analysis a good idea, but they can turn out to be a bad idea in the long run because there are many other things that you could do with open access, open wireless. So some people thought it would be a good idea to escalate it to the Court of Justice, so the European top court, except the problem was that when it went to the top court, and we tried to sort of draft some letters, trying to explain to the court that open Wi-Fi is very important for innovation. And we even convinced Advocate General, who is the guy who basically gives advice to judges. And Advocate General in his submission says, Wi-Fi access points indisputably offer great potential for innovation. Any measures that could hinder development of that activity should therefore be very carefully examined with reference to their potential benefits. And we were like, wow, great, fantastic. We convinced Advocate General. Then it went to the judges, and judges were like, I don't care about innovation. I care about human rights. And this, to me, doesn't seem to make any problem for human rights. Yeah, you password protect your Wi-Fi, so what? So here, the point that I had here, that if limits of these are only human rights, maybe it can be actually short-sighted in terms of how it moderates the measure. So, the outcome here was that they said, well, that's not really a problem for us. That's something that is acceptable. And of course, the overall problem with this is that, well, you need to have a trust in courts that they can think to the future that what they do might have impact for future innovation. And it's of course not something that doesn't happen in other areas, but here there are just many ways how you can institute something interesting. So that's a real challenge for the judges. So let me finish with the filtering scenario as the last one. So filtering is something you might be familiar with. There's a lot of debate about this, whether platforms like YouTube should have this as an obligation, right? So whether we should change the existing status quo. Well, these injunctions in Europe were used to impose filtering on these platforms, even under a regime where we told them from the total law perspective that they don't have to do anything but react to notifications. And then people came with injunctions and said, well, that's maybe true as far as your liability is concerned, but when it comes to injunctions, we want more from you. So in Germany, for instance, notice and stay down, something that you might know from media, is something that is already practiced for some time, even before the Commission came with its fantastic idea, but it's practiced on the basis of injunctions. Well, filtering was also something that people tried to impose on the access providers. So we had a real case where there was attempts to impose on access provider a filtering that would basically prevent infringement from happening already on the internet access level. So not even at the level of the platform, but already on the infrastructure level. But there the judges understood, though again the language is a human rights language, that this would cause a problem. And rejected it back in the days. But the main point here that I'd like to make here is that these measures, when they're applied to providers who are already subject to some form of incentives by doctrines such as secondary liability, it basically comes on top. So in a country like US, where so far this measure is not really existing, you would have a DMCA notice and takedown, you comply with that, and whatever you do on top, DMCA plus as it's usually called, it's completely voluntary. Well, except that in Europe, we have the same thing here, so we have the same deal, you have to do this. And then of course you can do this voluntarily, but if you don't, we can come with injunctions and try to impose it on you. So what is voluntary is sort of becoming questionable, and as also what is becoming questionable is, okay, but if this was meant to figure out the effective cost-benefit analysis, why are these measures basically rewriting this entire equation by basically telling you, well, notice and takedown is not enough anymore, now you should practice notice and stay down and actually filter everything up front. So to summarize the problems with this, the problem is that these measures, because they're so broad, they can very easily, and because how the costs and benefits are allocated, they can lead to waste of resources. Because right owners have no incentive to take into account the general societal picture, courts are not screening for this problem. Very easily, if the measures, in particular when the measures are not limited in time, they will just become costly, and we don't really know whether we're getting value for money, right? Second, right owners receive a very broad power to propose many things in a system like this. And they can de facto propose even what normally would go through legislation. And the question is this really something that is a good idea? That right owners have this possibility, that they can de facto use these measures as a way how to circumvent legislation. Next, the problem is, of course, of innovation, as always, in this area. Are these measures future-proof? Are courts able to foresee, as in our open wireless scenario, are they able to foresee what could be done with that technology when they implement particular choice? And fourth, well, maybe if you allow these measures also against people who are already exposed to some form of regime such as secondary liability, maybe you're actually rewriting how they should be behaving and basically undermining what you tell them in those doctrines. And on top, maybe you're actually creating a framework where it's easy to argue that we get injunction against you because I don't have to argue that you're liable, then go and argue secondary liability because you have to argue liability. And since there is not such a big difference between the two, in the competition of two remedies, people go for the easier one. So that's additional trouble with this. So are there possible solutions to this? So of course one solution is that many people would say, especially in the US, they would say, well, just go away with this. Abolish this and then you don't have these problems. Just fall back on the voluntary agreements again. So you can have these things happening by people just negotiating, right? But this is not happening in Europe, so it's not very realistic to propose solutions by just saying abolish it. Plus, I think the questions whether we should have them or not is an empirical question, so it's not a question that I could answer in this research. But we can think about solutions to the problems that I posed within the system, and this is what I end 2 slides on solutions. So first, the problem of waste of resources. So this problem that right owners don't necessarily take into account the overall picture, and the fact that this measure basically undermine other areas of law such as secondary liability. Well, what you could do there is basically do the following. Well, if the right owners are not taking into account the overall cost, if the courts are not taking into account the overall cost, how to make sure that the proposals that you receive that are made to the court are those that are welfare maximizing. So in other words, there are those that already you know that the benefits outweigh the costs, because those we would be happy with, at least as a first step. Well, the idea would be to maybe outsource the decision to the party that can make the decision best. And in this case, it's clearly the right owner, because the right owner has clearly the best access to information whether the potential benefit, what is the potential benefit. So what you need to do is basically expose them to the full cost, direct cost of their measure. In other words, in the equation of those costs, you need to basically say that implementation costs are also to be borne by the right owner. Because then the right owner realizes, well, I can go to the court, but now I have to pay for the implementation as well. So basically, if the expected benefit is higher than all these direct costs, and I underline direct, then that already indicates to the judge, well, probably it's welfare maximizing because they're willing to pay for this. Now, this is useful not only from this perspective, but also because it inbuilds the time limitation to this. Because if right owners experiment, they bring something to the table, propose, pay for it, and then it turns out for them that it's not very useful because people find ways how to circumvent this. They just stop paying and things dissolve. There is no harm, except for those measures that were in place for a particular time. The other thing that it solves, it prevents that there is overuse of this remedy at the cost of other remedies, such as remedies whose basis is in liability. Because you don't necessarily go now for this remedy because it's easier. Well, it's easier to argue, but now you have to pay for it. So maybe you make your decision with a more nuance there. And the interesting thing is that many people, when I propose this, they would think, well, this is just very controversial. How could you propose that right owner should pay for implementation by the intermediaries? In reality is that this has historical backing. So these remedies in both Germany and England actually have element of compensation inbuilt. So it's not so controversial as people would think. What about the other two problems? The problem of very broad powers given to the right owners to basically propose different measures that could be passed as legislation. Well, you can solve that by being more careful when screening out those proposals. And we have, in at least European human rights law, doctrine of prescribed by the law, which is basically embodiment of the rule of law idea, which is basically, well, you can impose measures, but they shouldn't be too complicated, overly complex, because it still has to be based on rule of law. So, and this has some sympathy also at the European Top Court. Advocate generals are proposing this, for instance, in that filtering case against access providers that I mentioned. In that case, advocate generals were in favor, but judges are so far not very listening to this. So in other words, what you could do is that you could think about whether three-strike scheme is something that is not overly complex to be imposed by injunction, because it just goes very far, and you can reject it on the argument that it's just not compatible with rule of law to use injunction as a legal basis for this, when the impact is such big. And now, of course, the last problem is the innovation problem. And I really don't have a good solution to that, because that's the most difficult to solve, because it basically questions your faith in courts and to what extent they can predict that the choice they make now, and makes a lot of sense from the static perspective, from the short-term perspective, will turn out to be a good one also from long-term perspective. And I don't think there is a way how to empower judges to do this. I think it's in a way inbuilt cost of the system. So if you accept the system as broad as we have in Europe, you kind of anticipated this cost will be there. You can mitigate it by allowing parties, for instance, to question it on the basis of innovation, but it's not that you can completely get away with this. You can at least soften it so it's not legislator who has to step in to overcome these measures, as it happened in the case of open wireless. And yeah, that's all on a very general level that I wanted to tell you about these measures. There are also some opportunities that I didn't mention, but I leave that for the discussion because there's so much to talk about there. So thanks a lot.
So I guess we can sit down now, right?
Okay.
You want to sit? What's easier for you?
Yeah, I can sit down.
Okay.
You can stand, otherwise
No one is going to see me, yeah, even though I have high heels. Okay. So thank you, Martin, for this great presentation, which was super clear and educating. So thank you for that. As I mentioned to you earlier, before when we met earlier today, this is super relevant to what is going on nowadays in Israel, and I think we should all anticipate more of these injunctions coming up in Israel as well, with the recent intermediate court in Israel recently granting such a blocking order against directed to an internet service provider, requiring it to block access to pirate website in NMC United, whoever knows the Hebrew case law. So this is super relevant to what is going on now. We have a pending legislation, the copyright reform legislation, that is purporting to set a procedure for obtaining blocking orders directed to internet service providers and requesting them to block access to websites. So I think that at this point of time, when this legislation is just about to be part of our settled law, it's very important to draw lessons from what is happening in the EU in terms of the legal foundation, the economic impact, the technological challenges, and the practical challenges as well. So this is the perfect timing, and we should thank Lily for this timing as well that made it happen. So I will start with criticizing, not criticizing this project or your view, because I'm with you on your side. But what I do want to criticize is the underlying justification for these injunctions directed to non-liable third parties. And I think that the main justification, and I think you might agree, is that the internet is anonymous and it's too complex to go after direct infringers, and that the intermediaries are in the best position to stop the infringing activity. However, when we zoom out intellectual property and copyright law and look at the broader material, specifically privacy law, where the call of scholars is that privacy is dead, and that with mass surveillance and big data analytics, you can effectively identify anyone is identifiable. So it seems kind of a weak justification to use this anonymity as a justification for this sort of judicial relief. And more than that, I'm not sure that intermediaries are indeed in the best position to stop the infringing activity, because as you demonstrated, and you have many more examples in your book, these measures like website blocking, for instance, which is the most popular injunction, are easily circumvented. Users can circumvent it easily, can bypass, change IP address, use a different server. So it's kind of, I don't know, it strikes me as not convincing at all to use these justification for these injunction. I'm not sure they are at all necessary. So this was just one initial point. Now, I think that the main problem with blocking measures, I think you defined it as the innovation problem, the third problem, is that they soon become technologically outdated. I think that the German Wi-Fi example illustrates it the best, that technology changes and then the injunction is totally irrelevant. So in this regard, I'm interested to hear if you know more about it from the EU perspective. What do EU courts do to try, I know this is the big question and this is hard for judges to deal with the technological aspects, but still I think that Judge Arnold, for instance, has recently used this injunctions that are time constrained and not forever. So this may help, or maybe other tools like using technical experts, or I think that even in the Cartier case, Judge Arnold did dive into the different technologies available out there to implement blocking measures, and perhaps different courts within the EU jurisdiction that we cannot read because it's not even in English, apply different, at least try to understand the technological impact of these injunctions. So if you know something more about this, at least myself would be happy to hear about it. And then another core issue with these injunction, I think, that relates to the privatization of enforcement, because what we see here is injunctions that are directed to non-parties, which are private profit-maximizing entities, which are ordered to implement various technological reliefs. So, of course, this immediately raises issues of transparency and oversight, and how can we really know that a private party actually do what the court has ordered it to do. So this goes to the balancing between, I guess, cost efficiency and accuracy. How do we balance the cost of implementing the injunction in comparison to its efficiency to block a circumvention, and also taking account its accuracy? Because when you block or disconnect, you may disconnect or block legitimate content. So how do the private party has to calculate and balance between these different considerations or interests? So I guess what I want to ask here, or not ask if you don't have answers, but just to mention that it's valuable to find out if there are safeguards and accountability measures, to find out, to enhance oversight, and to find out how the intermediary effectively apply these measures. Now, from a procedural aspect, I think that what struck me, and you also mentioned it in your presentation as unfair, is that, again, we're talking about injunctions directed to non-liable third parties, where the direct infringer is not necessarily part of the dispute, is not necessarily even in the courthouse to have his day in court and to argue or defend his own position. So I think that this is one of the major concerns here in Israel now from the pending legislation that we have. Okay, will the court will actually decide the merits of the case and decide the copyright infringement claim and analyze fair use and so on, or because the direct party is not even involved, it's going to be like hush hush and here you go, here's the order that you wanted. So I wondered how does this work in the EU, because I'm sure that the direct infringer also is absent for most of the procedures. So is there any, let's say, perhaps a public body that represents the rights of the direct infringer, or is there any guidelines that the court follow to I don't think I'm using this, I'm just holding it. Any guidelines that the court follows to no, I'm good, to ensure that the rights of the direct infringer are taken into account. And the last thing I want to mention goes to the slide with the DMCA plus this one, yes, which I really liked it. And so this is something in favor of these injunctions. I think that if I understood correctly, you say that this is like making the DMCA plus measures mandatory, which is like, but I'm not sure that this is exactly true, because at least if we're looking at the situation from this point of view, we're better off with these injunctions against third parties, because they at least are subject to ex ante review in the court, so the court kind of at least have some sort of review, whereas DMCA plus happens totally voluntarily, as you mentioned, outside the court, so there's no actual way to subject it to oversight and to check it. So yes, I have more, but I leave it for the audience for more Q&A, so thanks.
Okay, great.
Here you go. I haven't used this anyway.
So you might need to remind me then all the questions. There were so many great questions in there. So I think I start with the last because it connects with your first. And that is basically, I prepared this for discussion because I thought it might actually pop up. That if you think about these injunctions, right? So this is the world where right owners will have these injunctions, right? That's one world. That's, if you look for the coast perspective, that's where you allocate the entitlement to the right owners, because they can go to the court and ask and demand this and enforce this. And the opposite world is the world in most other countries where basically the reality is there is no such a claim, so you have to go to those players and negotiate, right? So that's the world without these injunctions, right? It doesn't mean that the same measure cannot be implemented. It just means that it has to be negotiated, or it's adopted unilaterally. That can also take place, right? So it's either bilateral or multilateral, where there is a deal, there's discussion, right? For instance, with website blocking, this is, for instance, what some people would say, that isn't it much better to have legislation for this than to actually have the private parties go and negotiate with right owners, and let's assume that the right owners would be willing to pay something for this, which they're not, which is the main reason why something like this didn't happen in many countries. But let's assume they would be willing to pay for implementation. And they would go to the providers and they would say, look, I'll give you the money that you need to implement this. Let's set this up. And let's say let's assume that providers would think, okay, let's do this for some reason where we're convinced, and they would strike a deal. Now, you have a website blocking scheme that it's not even subject to judicial review. Right. So is that a better world than a world with injunctions? I don't think so, at least not with respect to injunctions. Now, we had a copyright alert system, right, in the US that dissolved because it was probably not bringing benefits that people hoped for, right? So that's an example of a graduating response scheme that, again, was implemented as a deal in the industry. So these things can take place here. But without these measures, dynamic would be different.
This is the content ID one.
Exactly, that's a content ID world, which is an example of a unilateral, although in that case you could question whether it's not a little bit of a spin-off of litigation against YouTube, right? But yes, that's a content ID world. But think about it also from the perspective that even in this world, when these injunctions are there, it doesn't mean that deals are not made. Actually, what this does is it changes the bargaining, because now there's a credible threat by these people who basically know, depending on how the cost is allocated, that there's certain things they can get before the court. So when they go and negotiate with providers, they have a credible threat, and they know at which point what they can get from the court. So of course what they bargain about is somehow different. So what I just want to say here is that don't think that in this world with injunctions there are no deals being made. There are. And don't think that in a world without such injunctions is necessarily superior if only deals are being made. I don't think it's you can really say that. So from that perspective, sometimes it's actually good that we run it through the court system. Because the courts, as you said, can actually can impose safeguards, prevent abuse, and all of those things. And I get to specifically your question about how European courts are doing it. But there was one thing that I wanted to say with respect to this that now I forgot. Okay, never mind. So, so to your question about how courts are doing it with respect to the basically fine tuning, right? So, and you ask, what are they doing from the perspective of innovation because these measures become obsolete? Now, they are absolutely not looking at it from the innovation perspective. They are looking at it completely only from human rights perspective. That's the language that a court speaks, and to some extent there is overuse of that. But there's absolutely zero reflection on other values. That what I've shown you with Advocate General was really an exception. Apart from that, you hardly find in enforcement case law references to innovation. Sometimes you find references to barriers to legitimate trade that come from TRIPS. That could be somehow close to this, but you actually don't have very much of this. So when you have these things like time limitation of injunctions, they come from human rights law. So time limitation is something that was discussed also before the European Court of Human Rights, and I still think that Justice Arnold was actually inspired by what in some of the cases, some of the opinions were saying about the time limitation. Many of the abuse clauses are also coming actually from this background. Now, how do judges solve this problem of not having the actual target in the proceedings? Well. On one hand, I think the best approach and probably the best practice so far is what Justice Arnold and his fellow colleagues in England are doing. So that developed over the years into a system where basically they try to bring the website that is about to be blocked on board. So they try to issue notifications or at least require the parties to do so, and then they include always clauses, both for users as well as websites. Where basically you can go to the court and set aside the judgment or question its implementation even. Of course, the trouble with that is that sort of delays that. So in a regular fair trial, you would have a say from the very beginning, right? So you're notified, you can talk from the very beginning about the measures. Here, there's a decision made, and after the decision is made, then you are have a chance to maybe go and challenge that it's overbroad in implementation or that you shouldn't have been blocked, etc. So we completely sort of delay that, and best practice so far is only including clauses. Now, many courts don't do that at all. But in one of the cases that came from the Court of Justice of the European Union, we had Court of Justice imposing on member states in some situation that if they want to issue these website blocking injunctions, they have to make sure that users have a possibility to challenge in case there would be overblocking happening. Now the problem, of course, is how do you make sure that users have a chance to challenge? Because that's a private party. So the fact that it's overblocking, that would be a problem if state is doing it, doesn't necessarily mean that you have a claim against private party. So Austrian court had to deal with this, Supreme Court had to deal with this when they got back this response. And they look at this scenario and they said, well, I think it's the contract that allows you to have a claim. So they basically construe it as you have a contractual claim for unrestricted or internet not restricted of lawful things. I think that's a little bit of a challenge, okay, but that's what the court thinks. And you could bring it as a contractual claim against the provider, and that would give you this remedy. Or the court was kind of flirting also with the idea that it could be tort in case overblocking takes place, which again I don't think is so straightforward as the court suggested. So they are thinking about this, but I haven't seen so far really action in this regard. So, for instance, in the UK, there was an incident, I think, where overblocking took place, but it wasn't brought to the forum. I think it was then solved technically. So it's not that we really have too much experience with. We have experience thinking about it, but not necessarily actually dealing with this. But in either case, it's basically being delayed. So it's basically these people who are not involved but affected, or just giving a chance, not necessarily ex ante. And then you had a question about to what extent judges are able to make these decisions that basically measures won't be circumvented in the future, etc. Well, I personally think, and to what extent they can think about the benefits and all of these things, I personally think I'm very skeptical. So that's why I would think that it should be screened out by the private parties. It should be the right owners who make the decision before they go to the court. And you basically believe the signal because they're exposed to the direct cost, so you know they will pay for it. So at least they believe that they're receiving from the benefit more than they cost them. And you still moderate it by human rights, by other things. But and if that is not the case, then they're just paying more than they're receiving, and at some point they probably figure it out and just stop paying for it. So I personally I cannot imagine that the judges would be able to do this, and that's why my approach is rather to solve it through incentives than try to pretend that we are able to solve this through expert judges. So that would be my response to that. But of course, opinions can differ. And you had more questions? That's what I could remember.
Yeah, no, and I think you did it. The first was just a comment about the justification about the anonymity in the unit, but
yeah.
I get yeah, you did a great job remembering all this stuff.
Okay, let's open this to the audience.
Yeah.
Questions.
I think I should stand so I can see you.
So I'm going to start. So I think one issue that was really interesting is that you were really skeptical about the prospect of addressing this issue from the perspective of innovation, because you said that judges would be reluctant to address this, and they won't find the place to address this from or the implications of innovation.
Yep. European judges, I should stress, yeah.
Sure. And so, yeah, of course, I mean, in the United States, that would actually be the entry point into the discussion.
Yeah.
So the question is whether you can articulate it as a human rights issue. And I think that what comes out of your presentation is that, first of all, when you give injunctions against intermediaries, it has a broad scope. So that we all complain about the power of Facebook and Google. There it is, or AT&T. So now we give injunction against these players, right? So it has this very powerful scope, right? So this is the level and the broadness. It's robust. And second, from a human rights perspective, so it affects the entire population, right? And then the second argument would be that this is really changing the default. So if the internet, you actually assume that the default is the same, but when we think about filtering ex ante, this is changing the default. Default says that everything is available unless it has been removed by a court decision. When you live in a world of filtering, nothing is available. Or some things are available, decided by private parties, right? God knows what, right? I mean, here in Israel now we have corruption investigation that involve the media and the government, right? Maybe some things were removed, right? When we didn't even know about it. We don't even have a clue of. I mean, we know that there were some injunctions. Who knows what was removed? We don't even know what we don't know, right? So this definitely has to do, and is, again, I think that the same would go for anonymous internet. We sort of believe that we live in a world of anonymous internet, but if you have the Wi-Fi example that you gave, if you have to have a password in order to log in, then you're no longer anonymous. So this changed the default into identified users that are using the internet. So that becomes a human right, a freedom of speech issue, right? A fundamental right issue. And so the question is whether this is something that you think this type of argument, this line of argument, could be made in Europe within the fundamental right discourse.
So thank you. So I personally think that you definitely have to make all these arguments through human rights. There's just no other way that you will have people listening to you if you will dress it up as an innovation rhetoric. Because the courts are judges are not listening to it, and you certainly can make many of those arguments as you made from the human rights perspective. So it's not that the problem that you could label as innovation couldn't be in parts appropriated also through human rights. That's not necessarily the problem. It's more the fact that there are many things that couldn't, at least in my view, be covered by some fundamental rights, which are more about how do we want to govern the society, how do we want to progress, and there's no human rights to fantastic progress in a society or whatever. So from that perspective, of course you can and you should. I mean, in Europe we have to in a way. But I think it sort of misses out an important part of the picture, which is that there is still something beyond this, and we shouldn't be only using human rights as the only way how to look at these problems. But indeed, yes, I mean that all of those issues that you mentioned can be framed from the fundamental rights perspective, and they would be most likely by the court in Europe. Now, whether we're changing default, we will for sure changing default, right? I mean that's. If you look at also what is going on now in the copyright arena in Europe, where basically we're trying to force filters as a market condition on user-generated content platforms. That is something that actually comes from German case law.
Maybe you can just explain for them.
Yeah. So about a copyright reform in Europe.
About this requirement. Filtering
right in Germany, right? Yeah. So basically, using these injunctions in Germany, already from quite early days. So I think 2000s, we had many cases that were basically addressing, because the interesting thing in Germany is that the secondary liability in tort is underdeveloped. So actually, unless you intentionally assist someone, you cannot be tortiously liable. Up until now, there is some debate now about certain things, but in most of the areas, excluding patent law, so copyright law, trademark law, this would be the rule. Now, so as a consequence, many people went for injunctions instead, right? So this is exactly this kind of injunctions appropriating also other areas. And they went for this, and what's developed as a case law was basically that as a provider, you have to if there is an infringement, there is a notification. You have, for the future, you have to make sure that this work will not be infringed again, and you have to basically you have to spend some effort on that. So of course you never make it perfect. There's no way to make it perfect, but you basically have to demonstrate. And then the court cases ended up being about, RapidShare got a fair share of those cases, and until it went bankrupt, where basically the question was, okay, so what did you do? And then the debate started. Okay, did you use word filters? Did you use basic fingerprinting, hashtagging technology? Did you use fingerprinting? Did you use that? Did you search external websites, specialized search engines on external websites? And all of these things were prescribed at some point by means of these injunctions. Because anticipation was, if you don't do that, then can be injunction issued against you to do that. And now, of course, you could say, well, but still it's not a market condition because you have to get into trouble of being sued. The problem is that once you receive a cease and desist, there is already big incentive to actually comply, because otherwise it's imminent that you can get sued. So, and plus you would also need to compensate. So, in other words, that led to a situation where many market players basically started treating it as a baseline. So notice and takedown wasn't baseline anymore, but stay down was kind of baseline. And we never really answered the question whether that's compatible with European law, partly because the European Commission thought it's politically touchy to ask that question, and they needed Germany for other things. So, and then what happened is, of course, right owners came with the same proposal to embed it into law, as the proposal for everyone. And this is what we have now in the proposal, is basically that if you enter the market and you fulfill some conditions, which are, I think, not very strong, you basically have to have content recognition technologies, such as Audible Magic or something else. And this is basically obligation imposed on you, on everyone who enters the market. So it's not even being sued. So mentality there is completely the same as with injunctions. We don't care whether you did something wrong. Actually, very interestingly, when they made a proposal, they didn't even think about the sanctions in case you don't comply with this. And at some point we had as many back and forths with the commission officials, and at some point I was having private conversation, was like, but what is the sanction here in case you don't comply with this obligation? And I thought, like, yeah, well, that's up to member states. So now they already have it. They have explicitly that member states can, decide what will be the sanction. But the sanction won't be that it's copyright infringement. No. The idea here, member states could maybe decide to make it a copyright infringement. I don't know. But the idea really is that it's just a kind of administrative, normally, obligation imposed on you to comply in the market. And that all comes from this that I just mentioned a little bit earlier. Does it answer your question?
Yes.
Okay. Yes, please.
Are you familiar with any cases in which liable third parties that was blocked from the internet sued for damages caused by blocking the internet? Because nowadays, every day we go further, we depend much more from internet services.
Right.
Sometimes it's even medical needs. Are there any?
So you mean like on the website blocking scenario? So you're
internet blocking.
Right, so basically
when they block the broadband.
Right, but so you mean disconnection now?
Yes.
No, that I'm not aware. So we have cases on overblocking of websites which end up in the filter and are legitimate. We have many of those cases before European Court of Human Rights, and now a couple of them pending, mostly against Russia and Turkey. But no, disconnection, no. But it's partly because this is still a rare species. So the Spanish case is, with one other Finnish case, the only two cases I'm aware of that ever did this. And that Irish... Yes, they were disconnected. Well, what happened with that Spanish guy, that's funny. What happened with that Spanish guy was that he was disconnected, but he probably never learned about that because he switched provider before. So, it was without effect eventually, but for us lawyers, the precedent is much more important than what happened to that poor guy, and we don't know who that guy is. So,
The court doesn't give their opinion in the danger of blocking off the internet for liable third parties. The question never raised the damages that could be caused for the liable third party.
you mean in sense like when they are cut from internet and they want to claim damages against the provider? Oh, no, I'm not aware that there are such cases. No, I'm not aware. Which doesn't rule out that there are, but I'm not aware.
Can I add to that?
Yeah.
There are instances where criminals have been disconnected from the internet and they sued the government for depriving their right to access the internet. And in a number of countries, in the US recently, in the Packingham case, but also in India and in England, that managed to overturn government legislation that has deprived individuals of internet access. So I consider this case like this.
Okay.
How about unjustified blocking?
Mm-hmm.
Did anyone get compensation for this, or were there in a regime of that sort, you're looking for ways to push against it, right? So if there is any cost, that is any risk for the owners that are bringing these lawsuits.
So far, I haven't seen this being termed in money. We only see this coming again to the European Court of Human Rights. And I think most of the things that happen maybe as a consequence of these IP blockings are usually then solved by non-legal, non-judicial means. So they are notified and then just adjust this because it might be bad publicity. So I'm not aware that there would be a specific litigation now. In the we do have those cases now before the European Court of Human Rights that are about the overblocking, and there's a couple of old ones that are about, Turkey wanting to block a site that hosted something that was not respecting memory of Ataturk, and the problem was they couldn't figure out how to do this, so they blocked the entire Google sites. And of course, it turned out that there are some other people having sites on Google sites, such as Mr. Agdenitz, and Yildirim, sorry, in this case. So basically, we have those cases, and I think the biggest and most interesting is now pending. It's actually a case against Russia. It's a case called Zakharov, right? No, Zakharov, that's the privacy case. Kharitonov is the case. Zakharov is the one privacy case. Kharitonov is basically an interesting case where basically what happened is, and this is really interesting because it goes to the heart of what you were asking, is you had a Russian scheme for website blocking, not necessarily badly drafted. I mean, they allow for blocking for many different things, so it's not limited to one specific type of content. And they had some procedures. You had to put people on notice, allow them to basically remove something and everything. So I had all of that, and there was a state authority, whose name I cannot pronounce, that was basically engaged in making decisions that eventually, okay, this has to be blocked. And they would add it to the block and then send it and distribute it among the providers. And providers have their choice how they technically implement this. The problem was that providers, of course, don't necessarily have the technology and didn't want to pay for it. State didn't want to pay for it. They didn't want to pay for it. So they went for the cheapest technology, which meant that now 98% of the websites blocked are collateral. Unintended consequence. So this is a study by an NGO in Russia. So you can imagine that many things get overblocked. So some of these people started complaining, and Kharitonov is exactly a case like that, where basically someone ended up in a filter just because provider made a cheap decision because they wanted to save money. Even the ex-state teleco in Russia didn't have the technology. So they all went for the cheapest, and the consequence was this huge collateral. And that's a big problem. And the question there is, of course, and we submitted an amicus brief to the court. So if you're interested, you can find it in Kharitonov versus Russia. And so the interesting question there is, okay, but that decision is made by a private party. So the state actually did nothing wrong-ish from that perspective, right? So they basically just said, block this website. It's the private party and its implementation that is the problem. So there we argue that basically, and this was litigated also in the U.S. before in the CDT versus Puppert. So that's an old website blocking case from U.S. And the argument is simple: state is accountable for the action of private user because it could have anticipated that under the profit maximizing function of the private party, this would be the implementation and the consequence. So hence the consequences are to be, it's something that you can actually directly invoke against the state because the state should have made sure that this doesn't happen. In other words, state could have offered a compensation scheme. If the only way how to implement its policy was through expensive technology, then it should have compensated that technology or not be so aspirational in terms of what it does. But you cannot say that, well, you guys figure this out and you pay for it. And if you don't pay for it and actually go for cheap solutions with a lot of overblocking, we don't care as a state. And I think that's a very strong case there. I hope that European Code of Human Rights gets it right, that Russia will be accountable for this framework, although it's actually private parties who are doing these decisions. So that's going very close to the whole problem, right? That you have an injunction or a law that is empowering private party to make some decision, and to some extent you can anticipate how the decision is made, right? To some extent you cannot. But to the extent that you can anticipate, maybe it's the state that is still accountable. And that's a question that is still kind of pending.
Is there any influence by the GDPR on those points or issues?
Okay, well, so I'm not a GDPR specialist, but there is a debate now to what extent the filtering that the Commission wants to impose in copyright law can be compatible with the data protection law. And because data protection crowd is very powerful, Commission was even convinced that in one of the compromises that was kind of floated recently, they even explicitly had a carve out, which was saying that these measures have to be GDPR compliant. Now, whether that in real world will mean something, whether because of data protection law, the filtering will be limited in terms of the measures, because we will say, for instance, that completely completely monitoring the traffic on a service is just way too invasive. I don't know. That I cannot. I mean, I tried to have conversation with some colleagues about that, but there's no conclusion to it yet. But yeah, there is that debate because people say, well, filtering most of the time actually is involving processing of personal data.
It
Now,
becomes much more complicated while third party is involved.
yes, and it becomes even more complicated. So we'll have to see. But the way it's going, many things are open, right? So it's, for instance, one of the things that is open, and what I think the Commission itself doesn't realize, that when they're imposing these measures, they're not.
This is the announcement of the.
Okay.
No more.
We don't have to leave the room. We can stay. So when they're imposing these measures, they're just saying you have an obligation to prevent, and they say using means such as content recognition technology, and sometimes they even say proportionate and God knows what. But what they don't realize that they don't spell out what it really means to prevent. So they can end up in the same debate as we have with injunctions. And there's the whole theory about what the court will do. Will the court synchronize with what it does with injunctions, in which case maybe stay down wouldn't even materialize? Or will the court get the political message, which is clearly they want stay down, and basically actually expand this even for injunctions? That's something we don't know. But that's something that is ongoing. And there will be certainly iteration between these two, between injunctions and their scope and the Article 13, which is the whole thing about Article 13 in copyright law. In that proposal is that what is the spillover effect of that provision on all other areas, including terrorism and all the other, not to mention non-EU countries, right? The signal that it sends. Yeah. Okay. Yeah, please.
Is blocking or disconnecting the darknet feasible? If not, what measures can be taken against encryption in this environment?
Okay, I'm afraid I'll disappoint you here. I'm not technically. I don't have sufficient technical background to tell you whether darknet makes things more easy, more complicated from this perspective. But depending on the technology they're using. So if you use IP address blocking, assuming that there's still some server with IP address, that I don't see the difference. We could discuss to what extent not blocking, but filtering is challenged by, for instance, encryption. That's an interesting debate, for instance. When I was recently lecturing in the UK, someone asked me, okay, so how will this work with WhatsApp? When WhatsApp decides to encrypt its content for its users, but is also actually having user-generated content, and you could say is also providing access to public, because some of the groups can be public, they maybe also need to have filtering technology. How will they do this in case they encrypt the content? The answer is I have no idea. I don't think Commission has an idea either. But with respect to darknet, I really don't know whether there is some specificity. I don't know enough about darknet simply.
More questions?
I'll go back to the cost that you mentioned earlier, and I think that this was also debated here in Israel, where right holders from the one side argue that the costs are negligible for implementing these measures, and the internet service providers or intermediaries from the other hand argue that the costs are very high. Now, I can understand that if as long as you do not have the technology and you need to build the technology, it may cost you more. But if you do have the technology and you are an intermediary that had already been involved in this sort of proceedings, the costs are still high, because I think that I read in your book that we're talking about
So the marginal cost can be very different for someone that already is using that for instance, for child pornography.
And also, you mentioned it in the presentation, and I'm not sure you talked about it, that the costs deviate between a small entity and a larger one. So if you can
Right. So one of the issues here is that actually that implementation depends on the status quo, right? So marginal cost, the cost of changing the status quo is dependent on what you already are doing. So for instance, the blocking orders in the UK were decided in the in an environment where basically most of the big providers already had technology because they were using it for fighting against child abuse material. And because this technology was there, and I know that Justice Arnold uses always as a justification, he says, well, I made a decision on the cost on assumption that these technologies are already available. And I know that this is his view. He always, even when he was giving comments to my book, he always says, well, but you have to make clear that this is made on this assumption, right? That is, of course, true, as far as he's concerned. But even in the UK, it meant that some providers, smaller providers, actually had to contract technology later on when they got sued in some cases. And for them, it meant that they couldn't use in-house technology, but had to license it from the market. And that was what sometimes meant that actually for them it was more expensive, not on aggregate, but when you slice it to the number of customers, than it was for the big players, because big players could either develop it in-house or just have simply more subscribers who essentially pay for it. So that's one of the big things that, if you do something in the area of child pornography, it basically has impact on the cost equation also in the area of copyright law. Now, if you do something through the copyright law, then it will have impact on the policy debate in the area of child pornography and terrorist content, because if there will be filter for copyright, it's very easy to make argument then, hey, if you can do it in the copyright law with some trouble, then why can you not extend it, especially if you already have the technology? And of course, the problem is the technology and the areas are not essentially always the same, because I mean, if you think about that stay down that is proposed in Europe, the rhetoric all comes from the music industry. And for music, yes, there are instances where we're using this, but is content recognition technology for pictures the same? I don't know, because for child abuse material we use a very different technology that is not using fingerprinting, but is using rather hashtagging, the photo DNA. Will this work in the same way for literally works? So not with audio and not with visual? I don't know. How will this work for the neighboring rights, where originality is not even criterion? You know how many people are claiming ownership of white noise on YouTube? You might have seen that, right? So quite a few. So that's the whole problem, right? There's a lot of spillover between the areas, but the cases are just not alike necessarily. But sometimes it might mean that you facilitate indeed in other areas that the same policy is adopted.
And do you see the use of these injunctions more in other areas, like not in IP and hate speech or child pornography, or
so
they use it also?
So the problem is that there's no explicit legal basis, right? So for many countries, this is not something that you necessarily have as a baseline provision. Now, because people see that you can get this in IP, they ask, why is IP special? Especially, why is copyright special? And they're trying to get it. And one typical example that we have now pending, it's a preliminary reference from Austria to the Court of Justice, which concerns question whether in personality rights infringement, so defamation, there should be an obligation on Facebook in this case. I think it was about picture, whether there's an obligation of Facebook to prevent, and there you go back to this, reappearance of, and then there is a number of questions, of the same picture by the same person, or of the similar picture by whoever, and that's basically the question that is asked there. But the thing is that those cases are probably less frequent, because legal basis is just not European. What is European is limitations, and that's why it ends up before the European court. But the legal basis for the other areas, for instance, for defamation, there is nothing in the European law. So they wouldn't necessarily, if they do that, they do it on national level, but I'm not aware they would be doing it too much. So defamation is one of the areas where they try to do something like that in some countries, and but not in many other areas, to my knowledge. Yep.
Maybe there's something very basic that I don't understand, but how does referral to fundamental rights justify this mechanism from the beginning? So, because from my point of view, it actually undermines freedom of expression, for example. Mm-hmm. So, how does the court use these kind of justifications in order to justify the legal mechanism?
So the human rights that I was mentioning mostly were as you mentioned, as external limit. So they weren't necessarily used that much as a justification for the measure. But actually, something I did not mention, that they are indeed used. So in Europe, we have in the Charter, maybe you know, in the EU Charter, which is like kind of a human rights catalog that we apply when the European law applies, we have an explicit provision, Article 17.2, which deals with the IP, which says intellectual property shall be protected. That's it, period. And and many times, this provision is used to actually support these measures and to make argument that you cannot deny all the possible measures. So, in the website blocking case, in the Wi-Fi password protection case that came to the court eventually did the following. So, it looked at the measures, and the Munich court that was asking this question said, well, there's 3 ways that you can deal with this problem. You can block a particular ports. You can ask for the ID, and you can password protect the Wi-Fi. Now, the court looked at these 3 possibilities and basically kind of went through this, looking at what impact it would have on human rights of others, right? So using human rights as a limit. And it said, well, asking for ID, that's way too much. Blocking ports, I don't think was there. There was some other measure now I cannot think of. Basically, measure number 2 also doesn't seem completely right. Password locking, from human rights perspective, I don't see such a big issue. But that's not where the court stopped. The court went forward and said, well, maybe if this would be ineffective, normally you would just deny this and say, well, we deny this just because it's ineffective. But then the court says, well, but IP is also human right. And you should also have effective remedy. So if out of these 3 remedies, only one is going through the external limit of human rights, then that's the one that you should accept. So the court kind of, and that's, we don't know until now still, kind of prescribed even website blocking. So at that point, people were kind of got really scared because European Commission has a big initiative on open wireless. And then everyone was like, okay, does this mean that we now have to institute this? Or what does it really mean? But no one really followed up too much on this. But the point there is that they use Article 17.2, human rights protection of IP, as a justification that you cannot just reject all the measures, you have to give something to the right owner, even if it's ineffective. So that's the context. And 17.2 is very strong. It's just becoming bigger and bigger. Sorry.
By the way, it's the same in Israel, right? Fundamental rights, freedom of speech, and and property, right? We also have that, the same legislation.
Right.
Could be turned into a limit.
I wanted to ask on the procedural level, because you talked about the way you move to injunctions, but in courts, when you turn to requesting injunctions, the judge often requires substantial collateral to be set forth by plaintiffs. And this changes the equation. At times, some parties don't have such collateral, and this might deter requests for injunctions or allow some firms to do it in others. So is this discussion of the terms set forth by the judge prior to providing an injunction, do you analyze this or discuss it? Because like just saying an injunction without thinking what the back-end terms here, so it's incomplete.
Yeah, so most of these cases are, what I'm talking about is final injunctions. So there are very few member states, mostly Nordic member states, that run this through preliminary injunctions. Because the collateral that you mentioned is mostly, that, I mean, at least I'm not aware that this would also have some role in final injunctions. It is usually having some role in preliminary injunctions where you're not sure whether this is, the right thing because you don't know the merits yet. So you say, okay, so give me collateral to make sure. In all the website blocking cases that I saw that use preliminary injunctions as a vehicle, and that's minority, collateral was never an instrument that they would come up with. But it's an interesting idea that they would basically say that as they do in regular website the preliminary injunction scenarios, just give me collateral because we're still not sure.
In the U.S., many of these cases actually, this was the key decision because the preliminary injunction was what ended the case.
Yeah.
The case could go on and on. There's appeals, and until then, the company suffocates.
Yeah.
Here, like in Europe, it's quicker or.
No, so these are really all final injunctions. That most of it. So during the process, during the process is basically, so I mean it's a regular proceedings on merits, right? So it depends on the country how long it takes, right? Italy can be a little bit longer, Germany can be quicker, but it's a regular proceedings where basically there is a defendant, there is a question of law, and there is no more complication about collaterals and all of these things, because the only finite measure is this injunction. There is nothing more that they usually ask for. I hope that answers your question. I'm not sure. Okay. Thank you.
It's not a very specific question because I have to read the book and it sounds fascinating, but I just wanted to hear your thoughts on generally on the future of copyright in the sense that, well, we've seen these wars. They've been around more than 300 years since the first statute ban, and a lot of these things are basically lobbying efforts and a lot of market power which drives them to filtering, to injunctions, to a lot of different things. And when you responded about the WhatsApp, it's just we're moving towards a society in which everything's going to be a computer, everything's going to be connected. We're going to change the ways we consume content. It's not going to be traditional ISPs, it's going to be different players. And it's going to be really difficult to control copyright in that sense. So I really want to know, how do you see trying to flip? How do you see this market or your suggestions in light of new technologies, in light of the future, in light of
Yeah.
the fact that, just like you said, you cannot do anything with WhatsApp or with that.
Yeah, so I mean that's actually one of the reasons why I'm where my concern lies here, because combination of possible multiplication of players, which this will always be happening, and there will be just many more players involved, which means that it multiplies the choke points, right? Where you can basically ask someone to do something, combined with a very broad cause of action that is only limited by fundamental rights, and it's all given to judges, and right owners are not exposed to incentives that would even make them aware of the direct costs, makes me a little bit anxious about what they can do, because what is possible then is that you can turn judges into a kind of a standard setting a forum of what the optimal behavior by these intermediaries should be. And this is not a fiction. This is what actually some firms are already doing in a European climate. Last week, I also was approached by some firm, and they just told me that we're having a seminar discussing these things, and we would be interested if you just come over, since you wrote a book about this, because we are a player who basically works. They're kind of like I'm not sure whether it's a law firm. It's more kind of anti-piracy, but at the same time they're more balanced. They're trying to see from both sides, and their motto, at least how this was introduced to me, is that we want to work on the duty of care that is good for everyone, right? And they launched strategic litigation on this. So some of the cases like that you saw were actually outcome of that. Well, if that's the case, you have these players doing this, which is, I think, understandable. You have such a broad legal framework. Environment always changes. Then what happens is that basically you have everything run through the courts as the progresses. And I think this is what actually many practitioners like. That's what I at least gather from some of the people who litigate these things, is that they actually like the fact that they can always go, and it goes to Luxembourg, and then they go to Luxembourg and they see what the Luxembourg thinks, and then again they try something new, and they go incrementally step by step. So my worry is more about that. Courts might not necessarily be the best forum to get it right. Now, the problem is, would private deals be a better forum to get this right? I don't necessarily think that that's true either. So what's the optimal forum? I really don't know. But there is indeed a danger that combining a very broad possibilities for this remedy together with this ever-changing environment and multiplication of intermediaries will basically just allow a lot of legal innovation. Let's say it this way. Yeah.
How about the government or the legislators setting standards for this, so that the courts would not be working in a vacuum? So they would have some guidelines, go beyond just saying you have the authority of issuing an injunction, but there will be some technological standards that could be, not to define a specific technology doesn't make sense because it's just too long, it's just, but to set standards is something that legislators definitely know how to do, or regulators know how to do, and maybe that would be a better form. Because to go the way Judge Arnold went, to say this is an available technology, therefore I can easily issue an injunction, actually ignores the fact that once you have a legal duty, you are going to have better and better technologies, like you said. In pornography, the reason that we have, in child pornography, the reason that we have these very good technologies is because of the liability, right? In Germany, where now you're going to pay 50 million euros for hate speech, you're likely to have the best technologies ever that would target hate speech, right? Because or that you remove, right? I mean, I don't know whether there are any empirical studies. It's too soon to study this, right?
So, that's a fascinating question. I have one paper on part of that question, so I try to answer that in a second. But first, probably, I think that the challenge here would be that, as you say, I mean, the standardization couldn't necessarily go just with the technological stream, because that changes all the time. So we would like to be on more meta level, right? Now, it would be probably easy to do this for something that is less likely to change very quickly. Maybe blocking websites is something where you could develop protocol more easily. But I don't know, for filtering, I just feel that that would be very difficult to, even on some meta level, to define something that wouldn't change in a very near future. Now, I'd like to pick your point on the standardization and areas such as notification, so regular notice and takedown. So many people, when they argue now in favor of filtering and this copyright proposal by the European Commission, they say, well, prescribing this is also a good idea because this will actually incentivize players to develop better filtering technology. So I was at a hearing, and this argument was made, and usually Greens are against this kind of filtering, but they actually like the intuition, right? Because they do it, Greens, they have it kind of in DNA to say, well, we set an obligation, so you basically develop a technology, anti-pollution technology and stuff like that. Now, I think that if you look at notice and takedown, I don't think that best incentives for innovation when it comes to filtering technologies are set when you prescribe it. And my argument is following. If you would standardize exchange of notices under a regular notice and takedown, so it would be possible for you to scale up notifications, so it's possible to notify easily across the platforms, and at the same time you would tie it together with the idea that notices that are created by technology, so not by humans, but by technologies, have to be screened and achieve certain quality. Then you would create a market where you have two sides. You have the right owners who have homogeneous interest in enforcement, and you have the platforms that have interest in processing notifications, so they also want to have some technology. Now, if you compare this setup for incentives to develop the technology with the setup of prescribing, if you prescribe technology, the only person who is willing to innovate and adopt is the firm that has to adopt it, or also player who wants to license it, right? Like Audible Magic. But they are competing by this technology. So look at YouTube. They don't want to open up Content ID because it's competitive advantage. So you won't see these platforms sharing technology. No, they actually will use it as a competitive advantage, and then you will have some firms that will basically just license to those players who stay in the game, like Audible Magic, right? Many people start with Audible Magic and then develop their own thing. Content ID started there, Facebook's rights manager started there, and there are many other examples. So I think actually if you look at incentives for innovation, that's actually defying the idea that that prescribing it is much better way how to get there. No, I think a much better way how to get there is to standardize and incentivize quality. And that's something that could much better play out, especially if you have players such as collecting societies. Why are they not funding the collective filtering systems? They would find stuff online with high precision. They would improve them, since the entire industry is interested in that. Why are they not doing that? Well, maybe they're not doing it because it's not possible to scale it up in the current system, where it's completely truncated how you notify, because the protocol is not completely set, and there are technical ways how you are preventing some type of submission. We see that. But in a system where you standardize this, I really don't see why they wouldn't be doing that. Unless, of course, they want just someone else to take the cost, which is then, of course, a completely different argument to have. But in terms of innovation, I personally think that having it actually in the notice and takedown, standardized, where you incentivize quality, it's what I personally think it's the best way how to achieve this. There's a paper on that coming up when I finally find time.
Can I come back to the costs?
Of course, please.
Because holding an injunction is a costly venture, and this cost falls on the state in this way, because this is something that doesn't exist in a model that works with fines, right? So it's a very Israeli question, right? Because Holmes said you look at the law through the eyes of the bat, right? So I'm saying maybe in Austria you give someone an injunction and that's the end of it, but this is an ongoing problem that you need to examine if the injunction is kept. So do you bring people to court for holding that in contempt? And then, if I were a taxpayer, I would say, why do I have to pay for this? So, and this is not cheap. You need special police and things like. And in property law, right? So society upholds it, but society doesn't really care. So you just have like whistleblowers coming, and you have to check it out. So is this an issue? Do people talk about these costs?
Not yet, but I think that's the future discussion that we'll need to have, because indeed, as you say, that's not the end of the story. Especially if these injunctions are not very specific on what you should be doing. So there is a lot of margin in implementation. And so, for instance, Austrian way is to say block access, and you figure out how you do this. Just use reasonable measures. And then, of course, someone can think that this is not reasonable, so they go and then they initiate that a court should look at it in the enforcement proceedings for the contempt or something similar, for instance, for fines. And then they would have to have the whole proceeding again, right, about whether this is up to date and whether this is best technology, waste money again. So this is the debate that we are not having yet, because I don't think there are many cases yet about compliance, and that providers would be not living up to the standard prescribed by the court. I think so far, and I think this makes a lot of sense from the strategy perspective. So if I was the right owner, and I would also be interested first at standardizing that this is accepted by everyone, and there's still courts that are not necessarily accepting website blocking in Europe, or are having doubts about this. Once you establish this, then you fight on the next stage, which is basically you try to say, okay, but what you're doing, you could be doing better. So let's now go to enforcement proceedings. So that's the debate to have in the future. I am completely with you. And then the question becomes, the same as in criminal enforcement, is, okay, so do we want to subsidize this? And to what extent we want to subsidize this? And then that's the debate. To what extent IP infringement also maybe aligns with some public interest they want to protect? Trademark people immediately would say, well, country fees, there's also, health issue and security issue. Yeah, but copyright isn't necessarily also always, and that's the debate to have as well. Yeah. So my model and what I propose makes a lot of sense if you're agnostic and if you don't believe that there is some public value in enforcing it. So basically the whole idea is you just subsidizing private parties' enforcement. But if you, and this is what Justice Arnold said when he reviewed my book, he said, but you're assuming that there is not public interest maybe behind some of these actions. And that's completely true. So if behind, for instance, some of his blockings, which were about counterfeits, there's a public interest, then maybe it's a good idea to spend some money on that. But that you shouldn't accept that as a starting point, I think. Yeah. So, but that's a very good point. I think that will be an issue in the future.
I think you already said it before, but it's probably stalled
two parties from setting very efficient bilateral agreement many before.
Mhm.
They could set the bilateral agreement outside of court before.
Yeah. Yeah, they could have done that, but but we also observe that they are not always interested, and that's a strange thing, that there sometimes are situations, for instance, not with access providers, but you have advertising networks. Advertising networks were for a long time not interested in weeding out copyright infringement so they wouldn't be interested in preventing that their ads are also shown on websites that have infringing material, but massively infringing material. And the industry was complaining about this. It's like, look, we brand owners, we are paying for this advertising, and then you show it on the pirate websites, and you even waste our money there double, and twice. And so they were pushing advertising networks to basically change. And there, I think it's really irrational, or at least it's not rational from the short-term perspective, for the advertising networks not to improve the quality of where they place the advertising. Because you would think, well, if you improve the quality of where you place the advertising, increase the value of advertising, hence it's actually much better. You make your customers happy. But I think there, it's maybe a problem of just being myopic, right? You get a lot of money now, so unless you're really forced, why would you change that? So I think there's a lot of deals that are just blocked by people being myopic. And then sometimes there's this sense, you know the ultimatum game? Ultimatum game is basically this game where basically you have money, and you're basically told, okay, so you have money, you have to split this money, and you give that second half to someone else, and that someone else can accept it or reject it. If he rejects it, you don't get money either.
It's called the chicken game.
Okay, chicken game.
Also the chicken game.
All right.
Please explain.
So, and if you and the rational thing would be, of course, for anyone to accept whatever he's offered, right? Because even if you get €1 out of 10 euros, that's still better than nothing, right? Because if you say, I don't want to accept this, then the guy doesn't get it, but you don't get it either. So you should basically accept any offer. So rational decision would be to accept anything. But what it turns out that people don't. And why? Because they feel it's unfair. If you, out of 10 euros, give me €1. So they punish you, but basically no one gets anything. And I think this is what is going on in some of these negotiations between right owners and providers. So they basically realize, well, look, yes, I could offer you something, but I find it unfair. So I don't do the deal at all. I rather lobby and change the law. So you have to do it yourself. But there's a lot of rational, deals that could be rationally explained, but it just never take place. And that's a problem as well, right? Why it's not taking place. Then it happens in the political arena.
Or in courts.
Or in courts, yeah.
I guess on this happy note, we will thank you for this fascinating talk.
Thank you very much.
Thanks, Maria.
Thank you.